some of the issues here, we talked about in general as an employee, can you be let go from your job? Based on what? Thank you. I heard in this general area, employment at will. What does employment at will mean again?
You can be fired for any reason.
Good. Eduardo said you can be let go for any reason, right? As long as what? It's not discriminatory. So that was where I said we need to talk about discrimination. And it's such an important issue that we're going to spend a lot of time on it today. So here's where we left off last class, and we're going to talk about discrimination protections. Go ahead, Senya.
Do you need to give them a reason?
So you don't have to give them a reason. If you don't give them a reason, they could sue you. And then you might run into an issue where they're going to say, well, you never said it was based on my performance. It's based on this. But really, they don't have to. They normally will. Okay? Because if you think about it, if I let Senya go because she's a poor performer, I don't tell her why, she's going to feel like, oh, no, maybe it was because of the fact that I'm a woman. And so then it's more likely she will sue me, which they want to avoid. That's expensive, whether it's right or not. And then on top of that, because I didn't give her a reason, like that's almost evidence that, hey, there wasn't poor performance there. I should have documentation that she was a poor performer if I don't want to run into issues where she's saying, no, it was actually because I'm a woman.
But if I say that I don't like your work or I don't like your attitude or
If you don't
can do that like that? Or?
Yeah, if you say, I don't like Hannah's attitude, she just has a funny looking nose, that's not protected under these discrimination laws. She has a right to let me go. Okay, the issue you'll run into is then the employee has a right, we're going to learn now, to say they can argue you were discriminating against them. Remember, you're innocent, right? Innocent till proven guilty. So as a manager, a lot of what you'll end up doing in a lot of these organizations is keeping a record. If someone's being a poor performer, you really want to have evidence of that so that if they do sue you and say, no, it's not that it was bad performance, it was based on one of these discriminatory reasons, as an employer, you can say, no, it was poor performance. It's clear I have a record of all the times you messed up. So for example, if you have someone coming in late, I've seen managers literally like sitting at their cubicle waiting so they could document this person was late at this day. Or they'd have them log into the system. There's even fingerprint systems to have people log in. I've had managers that I worked with as a consultant who they had employees that were just doing low quality work. So when they'd submit that low quality work, they'd say, this is not good, you need to try again. And then they'd try again and it still wouldn't be good. They'd usually have somebody else do like the right quality so they'd have a comparison and they'd record that as well. Documenting anything wrong. The problem is a lot of times managers don't like to give poor feedback. It's uncomfortable, it's confrontational. To say like, hey, you're doing a really bad job, right? It's a harder thing than just saying, you're fine, it's good, keep doing your thing. And so they'll inflate feedback and say, you're a rock star, and yeah, you're great performance review. And then all of a sudden you're coming back later and saying, well, I don't want Delia to work here anymore because she has bad performance, and all she has in her record is a history of stellar performance reviews. It could look like then maybe it's because she's a woman. So you want to be careful as a manager to really document to avoid issues with this kind of a thing. Now we talked about that a lot last class in terms of the Equal Pay Act. And remember, you should be paid an equal wage for equal work. It should not be paid a different rate simply based on gender. Now, could it be that I, as a woman, am paid differently as Henry is for the same job?
Yes.
Yeah, and it could be because Henry has more experience. It could be because they offered Henry $15 an hour and he said, no, I want 20, and negotiated and landed at 18. Whereas I was like, woohoo, $15 an hour, I'll take it. That can be some of the differences. That's fine. There's often different pay in jobs. You just want to make sure it's not only because of their gender. And again, we watched a video last class about this. There's a couple of videos here for those of you that are interested. We're going to move forward now into the main discrimination law. So we're going to see a few today. The main one that protects the most groups is known as the Civil Rights Act. It's from 1964, so it's a little over 50 years old now. And Title VII is where we see a lot of the protections in place. Okay. Under this law, it prohibits employers from treating you unfairly differently simply because you are part of one of these 5 groups. What are the 5 groups that are protected? Go ahead, Jonah.
Sex, race, color, religion, or national origin.
Good. So sex, race, color, religion, national origin. Let's look at each of those. Sex, okay, they're referring to your gender. So we'll talk in a moment about a couple gender issues that get included under the sex piece. Race can be a really big problem. There's been a lot of discrimination, and there still is today. Okay, some of it is very blatant, horrible things from ignorant people, and others it can be a little more subtle, but it's still happening. Now, color is separated out from race. Why is that? Why do they have two distinct groups for that? They protect race and then they're protecting colors separately. Why?
Because you can be the same race but different color.
Thank you, Sonia. You can be the same race but different color skins. And based on the shade of your skin, you could still be discriminated against even within your own race. Maybe for having darker skin, lighter skin, and so they've actually spelled out a separate protected group based on that. Religious beliefs is another really important one. Okay, this is something that applies also in your academic setting as well as the workplace. There's been some issues about this. If you're interested, there's a famous case with Abercrombie stores, Abercrombie Kids versus Abercrombie versus EEOC, the Equal Employment Opportunity Commission. And they had a woman who they were not hiring because she was wearing a headscarf, and so they were saying, well, you can't wear our uniform, and she sued and was like, well, this is for religious reasons. You know, you can't not hire me based on the Civil Rights Act. That's discrimination. So a thing to be careful about when we talk about in terms of your classes and your workplace. So if you work in a retail store, when is like the busiest time of the week in a retail store? Weekends. So as a manager in a retail store, usually you want all hands on deck, right? All employees available. Now I'm Jewish. We have something called Shabbat from Friday night to Saturday morning. You're really not supposed to be working. You shouldn't be driving. So working on the weekend would be really difficult for me, depending on if I'm a very observant Jew, it's going to be difficult for me to do that. Now, does that mean I just tell my boss, like, I'm not showing up Friday? They put me on the schedule and I just don't come in? No, what should I do?
Make previous arrangement.
Thanks, Anya. Yeah, make a previous arrangement. So remember, it needs to be a reasonable accommodation. You need to just let them know. If they don't know, that's going to be an issue, right? Don't be difficult about it. But if you're saying, hey, you know what, I can't come in on Friday night, it's a religious holiday for us, then they're supposed to, if they can get Maya to work instead, they're supposed to do that. Now, if it's all hands on deck and they definitely need everyone there every Friday, they could say maybe it's not a reasonable accommodation. It could be disputed. You had a question, Jonah?
More of a statement about that, because I've had a lot of experience with this. There are people who don't realize what reasonable accommodation really means, and that basically if it's specified in the job description that you need to be able to work 24/7, no matter what, they have a right to. Actually, I think the way the law works, my brother-in-law looked into it for me. The way the law works is they can't not hire you. They still have to hire you. However, they have a right to fire you for your first violation of it.
Interesting. I would say that's going to vary based on the state. You'd look to precedent to decide what exactly is reasonable. And I think an employer could have a good argument. If they're saying, we have a policy, all employees, we need them to be here to work on a Friday night, you could run into an issue with that. They could say it's unreasonable to have someone who can't be here. Now, if it's, I can have everyone here except for one person, and you happen to choose Delia instead of me to have that Friday night off, well, now we have a problem. It seems reasonable that you could give me that night off so I could keep working there. So the reasonableness, that's where you're going to run into issues of whether or not the employer versus you thinks it's reasonable. The other piece of this, the last one, is your national origin as well. So again, if it's in the job description and it's required as part of the job, you still need to be able to do the job, but if they can reasonably accommodate you, they should be. And they should not be treating you differently simply because of one of these 5 protected groups. Now, I want you to be careful about this. Not every group is protected, right? So, like, if I smoke cigarettes, am I protected under the law? No, there's not a law that says they can protect me. So if they want to terminate me because I'm a cigarette smoker, the person who owns the business is really against cigarettes, can they do that? Yeah, they're treating me differently because I'm a smoker, but we don't have a law that protects smokers right now. Question, Eduardo.
There are also bosses are free not to follow that rule if it is below 50 employees.
For Title VII, they have to follow this. There's not a threshold. Some of the laws, you'll see that there has to be 50 or more, or 20 or more employees. There should not be discrimination at all in your workplace. Okay, this isn't one of the ones that has that threshold. So another piece of this down here, affirmative action. What's that? It's not like prohibited in this law. They also don't require it. But what is it, Riley?
It's when you try to hire people based on their race or origin to make it a diverse workplace.
Okay, Okay, so you're hiring, you're trying to make a diverse workplace, so maybe you say, I'm going to hire, 3 women and 3 men to work here, so it's more diverse. Okay, and that's something that we call affirmative action, and that can be okay. The courts are starting to move a little bit away from it, because some people would argue, well, that's discrimination. That's making a hiring decision based on gender, right? So the idea behind affirmative action was there was a lot of discrimination in the past that they wanted to try to even out the score, and so they had these affirmative action efforts put in place where they said, let's try to give, extra benefits to these groups who were discriminated against in the past. So for example, most of you said you want to transfer to another institution after you get your associate's degree here and further your education for your bachelor's degree. That's awesome. When you go to transfer, they're going to look at, things like your race, your national origin, your gender, because they want to have a diverse student body, right? They want to make sure you're not going to be uncomfortable going into an all-male school when you're a woman at some of these universities. So they look into that. They want to make sure that they have a diverse student body. And so as part of that, it could be a factor in your application. Now the courts have decided it can be a factor. It should not be a quota. So they shouldn't be saying like, we are going to make sure we have 10% women. But they can factor it in to their decision in the application process. Now employers, it's a little different. Employers, things like our government agencies, they actually have some contracts that are supposed to go. They say like 25% of their contracts are supposed to go to small businesses, and they can say like the other 25% are supposed to go to minority-owned and women-owned businesses. So they have affirmative action efforts in place still, and that's okay for some of our employers to have. Now, sexual harassment comes under the Civil Rights Act under which protected group?
Right.
Sex, right? Sexual harassment has to do with your gender. Okay, so they consider that a gender issue. Who has had a training on sexual harassment on the job before? What is that training like? I have a few hands up. Anyone want to share? Go ahead, Sebastian.
We could watch videos on previous like examples pretty much.
Good. So Sebastian
What
said,
what's wrong.
yeah, you watch videos with examples and they ask
Yeah,
you
they
what's
show you
right.
like what's wrong and what's right.
What's wrong and what's right. And they're pretty easy, right? Some of them. So this is the one that's pretty obvious, right? Some of the videos will show you things like a person touching somebody's butt in the workplace and say, is this okay? Does that seem okay?
No.
No, so that's easy. You say, no, I shouldn't be doing that, right? There's some other forms of sexual harassment that people are not always familiar with. We're going to talk about a little more today. The one up here, there's 2 types, quid pro quo, and down here, hostile work environment. The one up here, quid pro quo, most people know is not okay. Quid pro quo means if I give you something, you give me something, tit for tat, right? So this is a manager saying, if you go on a date with me, I will give you an interview. If you go out with me, I'll promote you. If you have sex with me, I will give you a raise. Do those things sound okay?
No.
No, right? So you're going to be good in your training video. A lot of offices train on this to avoid these issues. You're going to say, no, you shouldn't be doing sexual favors in exchange for a job. Now, this can also be more subtle. I will give you an example. At one of the places I worked when I was a little younger, there was a manager who had a crush on me. I don't know why. He had a crush on me, and he would change our schedule so that I worked at the same time as him. Now, because of that, I actually ended up with some of the better shifts. So even if you don't want to complain, the other people in your office could complain for you. They could file a complaint about it. Because that stunk for the other people I worked with, right? They were missing out on like the awesome shifts because this guy had a crush on me and was using that as a way to schedule me. And I didn't even like notice for a while. And then I was like, huh. When they pointed it out to me, and I didn't want to cause issues at that time. I was young, and I was like, I do my job, and they actually reported it because it wasn't fair to them, right? That's not a fair reason to be making a schedule. So you want to be careful about that in terms of quid pro quo. It can be a little more subtle. And on top of this, you see a lot of businesses don't handle this very well. When they did report it for that gentleman, he was not fired. He was moved to a different location. And that's what happens a lot. They kind of avoid the problem, and by relocating the employee, that way they don't face lawsuits and all this other fun stuff. They kind of are just like, under the radar, and they move them to another place. He had actually had a history of a couple other complaints and still was not fired. So that's something that some of you might experience. Okay, with the quid pro quo, it's a little more obvious, right? But it can be a he said versus she said. A lot of businesses now videotape. So if they're doing really inappropriate stuff, a lot of it can be caught on film. Or if it's something like, changing a schedule, that was easy to see there was an issue, right? The hostile work environment is where there could be more issues where people are not aware of. So touching someone in an inappropriate way, we all agree is not okay, right? Now, the way you touch them can be unclear. So I'm having a really rough day. I look really stressed out. One of my colleagues comes and starts massaging my shoulders while I'm sitting at my desk. Is that okay?
With your
Allison, you're going, no way, why not?
weird.
It's weird, right? Now, would some people be like, that's fine and it's comfortable and not mind?
Well, depending.
Maybe.
You want it
If you
or
want
not.
it, you consent.
It depends, right? It depends on if you're comfortable with it. You don't really know if someone's comfortable with it until you try. You don't want to risk that, right? So you should not touch somebody else. Some people could be uncomfortable even with like a tap on the shoulder, right? You don't want to touch anybody else at the workplace. It could create a hostile work environment. Now, the big way we make this a hostile work environment is if they ask you to stop. You know, someone comes up and starts massaging me and I say, please stop, and then they keep going or they come back and do it another time. Now they've really created a hostile work environment. Because not only is it offensive to me, I've told them that and they keep doing it. You know, now we have a problem. We don't want to be unreasonable here. You know, if it's something like they just, you know, shook me on the shoulder, they're trying to get my attention, they probably did not intend to make me uncomfortable. They might not know. Now that doesn't seem as fair. Grabbing me on the butt could be a whole other story, right? That seems pretty obvious. So here they're going to look to, like, what would a reasonable person feel? Would a reasonable person be offended? And then on top of that, were you offended? And by saying stop, and they keep going, it's very clear that you are offended. So you should say stop. Now, where this can also be unclear is in terms of verbal discussion. So physical touching, we know, just don't do it, right? We don't want to make someone uncomfortable, and sometimes we're not sure. Verbal conversation can also create a hostile work environment. So if you are sitting there and we're in a room like this and you're talking really loudly, hey, I had so much sex over the weekend, and you're saying really kind of raunchy things, you could be making the person next to you uncomfortable. Even without touching them, even thinking they're not listening to you, you know, you're creating an environment where they're uncomfortable. Now, again, you should say stop. And if they keep doing this kind of thing, that's where we can create a hostile work environment. So just be careful about what you're talking about and what you're doing in the office. Deborah, you had a question?
Yeah, so is there like laws that companies protect employees? Let's say if there's a customer that's like sexually harassing an employee. Like okay, so like I had a manager from at the retail store, she was getting actually stopped.
Mm-hmm.
Does the company have laws for that or something? Or like
If you are being harassed by another person, we have lots of protections. So under tort law, right, you can experience a battery if someone's touching you in an offensive way. So this isn't the only option. Okay, generally this relates to actual employees in the workplace. So you usually go after a customer if there was an issue like that for a battery. Okay. Pregnancy, there's a separate act protecting pregnancy issues, the Pregnancy Discrimination Act. However, it's also included under the Civil Rights Act. Which protected group do you think pregnancy falls under? Women, yes, gender. Thanks, Javon. Gender, sex is a protected group, so pregnancy will fall under that. You should not be fired or refuse to hire someone simply because they're pregnant. And I have an example of this same business where we had the harasser, not the harasser who hired this person, a manager who was good. He hired a woman to work for him, and she's about 4 months pregnant. If you're not familiar with the pregnancy stages, a lot of women, you can't really see that they're pregnant at that point. Some you can, but some you might not. So he hired her not realizing she was pregnant, and so she starts working a few weeks later. So she had about 3-4 more months and her pregnancy left, and then she was out of the office on maternity leave for a few months. That seemed like a fun thing for him to have to deal with? No, but it wouldn't be fair to her to miss out on this opportunity simply because she was pregnant. So that's an example where if he had known she was pregnant and said, I'm not hiring her. You know, she's 8 months pregnant, it's very clear she's pregnant. He could be in violation of the Pregnancy Discrimination Act, but also the Civil Rights Act. Jonah?
Is it possible in this situation to say, hey, like, can we just like offer them a job to start after the pregnancy, or you're still not allowed to do that?
You'd still be discriminating against them because you're giving them unfair treatment, right? Somebody else could start
Okay,
before.
but
But
if
you could agree to that.
if you offer them the option, hey, would it be easier for you to start after?
And you can agree to that.
Okay.
That's totally fine. Most people might not want to because they want to start getting their health insurance, but you can you can always agree to something else. You know, as long as it's an offer and not a we'll only hire you if you start later. Yeah. So I want to show you an example of this. I'm going to answer Cynthia's question first, and I'll show you the example.
I have a friend that she was working in a company like 3 years, and then they have to lay off people,
Mm-hmm.
and she was pregnant at the time. So she was laid off,
Mhm.
but no was only her, it was another people too. So it was kind of not totally correct because she was pregnant. I don't know if that legally they said we are letting off you not because you are pregnant, because we are letting off more people.
Yeah, that'd be really dumb to say I'm laying you off because you're pregnant, right?
Yeah, of
That's
course.
just a bad move. So Sammy's bringing up a really good example. They're doing a bunch of layoffs, right? Let's say they're laying off 10 people and one of them happens to be pregnant or happens to be, black. And so they're going to say, you can argue, they can bring a lawsuit against you and say this was a violation of the Civil Rights Act. You're discriminating against me. You laid me off instead of this other person. Because of the fact that I'm a woman, because of the fact that I'm black, and that's protected under the Civil Rights Act. The company is going to argue, no, we chose these 10 people, and so it's good to show the reasoning behind it. It could be we chose these 10 people because they have a record of the worst performance, and then you'd really want to make sure you have a record of that. Or it could be we chose these 10 people because they were the last hired. We were trying to keep our more loyal employees. So as long as it's consistent, and it doesn't seem like it's for one of these reasons, they should be protected. Either way, you're running into a lawsuit, which is expensive and time-consuming. So many employers will just settle, right, to avoid the issue. Like, here's some money, just to not end up in court. The other piece of this, keep in mind, a lot of these businesses, they don't want the optics, the public relations. They don't want the media finding out about these things, and it could make the business look bad, whether it's actually happening or not. So imagine the pregnant lady who loses her job going on the news and saying, they fired me, they let me go, and now I have no health insurance, now I can't pay for my baby, and you're going to feel bad for them, and whether that was the reason or not, it's going to make XYZ company not look great in the public eye, and it could hurt their market. So many businesses, to avoid those types of issues, will just settle the claim. I want to give you an example here. I'm sorry, I'm a big Bang Theory fan. It's been out a while. Any other fans in the class? Thanks for not leaving me hanging. I also have a kid, so I haven't seen any of the new ones, so don't tell me anything. Okay. Here from the Big Bang Theory, where we can see some sexual harassment. I want you to take a look and see what you think is sexual harassment here. Let me turn on the volume. Loudest.
Human Resources Department. Human Resources Department. Human Resources Department.
Come in.
Hello.
Dr. Cooper, have a seat.
Thank you.
I called you in today because your assistant, Alex Jensen, has lodged a complaint against you.
So I've been told, but I can't understand what she has to complain about. I mean, she has a front row seat as I make scientific history, but there's string cheese in my mini fridge, and that's for anyone. Yeah, and just yesterday, I led her away from a life of sexual promiscuity by making her look at pictures of disease-ridden genitalia.
Cancel my next appointment. This is going to take a while. Dr. Cooper, you said things to your employee that you just cannot say in the workplace.
Like what?
Well, according to Ms. Jensen, you said that she was a slave to her biological urges and called her an egg salad sandwich. I don't even know what that means, but I'm going to go ahead and tell you can't say it.
Oh, I see the confusion here. No, Alex thought I was singling her out. No, I meant that all women are slaves to their biological urges, even you. You're a slave.
I'm a what?
I'm just saying, at a certain point in a woman's menstrual cycle.
I can't talk about that either, Dr. Cooper. Your language is entirely inappropriate, and I'm going to advise that you shut your mouth right now.
Yeah, well, I'm not saying why I'm the one being persecuted here. Dr. Hofstadter, he was bragging about his sexual desirability to anyone who would listen. And Howard Wolowitz, he spent 2 years using university resources building a 6-breasted sex robot.
What seems to be sexual harassment in the video clip you just saw? Everyone was laughing. What? Right.
He made a woman with a diseased genitalia.
Yes, so he had this woman looking at genitalia. You know, even if we take out the diseased piece, I mean, you guys are looking at these sexual parts of the body. Does that seem okay? Probably not. Anything else, Javon?
Well, I think like that wouldn't be an issue if it was part of the job, but it was like what he said after that. He was like your sexual desires.
Oh, that you're a slave to your sexual desires. Does that seem
Yeah.
like an okay thing to say?
I feel like that was the unokay part.
Yeah, that was not okay, right? That could be offensive as well. Anything else there? On sexual harassment, did he say anything that seemed discriminatory? Sebastian?
That you're a slave.
Yeah, he's called her a slave. That was not a good thing to say, right? So he's saying a lot of things that make these people uncomfortable. You want to be careful what you're saying and doing in the workplace. That was a great illustration for you. And it wasn't just because he said it to one person, right? He's like, oh, I see. You think I'm, treating everyone differently. And he starts saying it to the other woman too. Now, you don't want to be creating this type of workplace. Now, we talked about sexual harassment. There were two types. Which type does this seem to be? Is it quid pro quo or a hostile work environment that Sheldon created?
Hostile work
Why is it a
environment.
hostile work environment? Okay, so verbally, he was making people uncomfortable in the workplace, and it sounds like she asked him to stop, and he kept going. Okay, so we see some examples there of things that aren't okay, and then we hear Sheldon talking, he's ratting out all his friends. Leonard's talking about, oh, I'm very sexually desirable. These are the kinds of things that, are not as blatant as we imagine, but certainly can be considered sexual harassment as well.
Can be like jokes, or when people are joking about.
Jokes, yes. So you don't want to be making jokes or talking about scenarios, or your friend did this, or you did this. If anything's going to make someone uncomfortable, why do you need to talk about your sex life in the workplace? Right?
I have a friend that they have a chat like in the office, and some of the one woman was doing sexual jokes and doing posting videos and something, and then the men say, no, stop, you have to stop doing that. And she was like, oh, you are too sensitive or something like that. But that's hostile work environment. Right?
Yes, so Cinya's giving a really good example. We have a woman posting videos about sex stuff, making jokes about sex. The men have said, this makes me uncomfortable, please stop. And she's like, oh, I'm just joking, stop being so sensitive. Well, if they're said stop and you keep going, it's a hostile work environment. Now, another piece of this I just want to point out to you, because there's been a lot of controversy around this lately in the news, especially around like male versus female bathrooms when it comes to transgender in different locker rooms at gyms, in different stores like Target. We've seen issues like this in the news. Transgender and sexual preference are not specifically protected under the Civil Rights Act, right? But as we started seeing some of these issues come around, remember the Civil Rights Act came into place in 1964. So now we start seeing all these transgender issues, we see sexual preference issues that are more prevalent in the media, and so we're trying to figure out, well, is this protected under the Civil Rights Act? There's been precedent, as well as the Equal Employment Opportunity Commission, the agency that was created under the Civil Rights Act to help protect against discrimination and prevent it. They've said, yes, transgender and sexual preference issues are protected under the Civil Rights Act. Under which of those 5 groups? Gender. Thank you, Delia. So they're including this, even though it wasn't specifically said in the Civil Rights Act. They're saying these issues fall under that gender class that's protected. So if you want more information on that, you can go to the website. Now, here's where I have students make mistakes on the exam. We talked about 5 groups that are protected under the Civil Rights Act. There are other laws that protect other groups. So the Age Discrimination in Employment Act protects people who are 40 or older. I get a lot of students who say, well, under the Civil Rights Act, you can't discriminate against someone based on their age. That's not a protected class under the Civil Rights Act. They have their own law. So remember, these discrimination laws protect different groups. Okay? So the Age Discrimination in Employment Act, they say, hey, you need to not discriminate against someone because they're 40 or older. And don't say because they're old. If you meet someone in their 40s and call them old, they will not be thrilled to hear that, okay? Just 40 or older. But the idea here was there's a lot of employers who had people working for them for like 30 years. They started out in their 20s, they're in their 50s, and they go, you know what? While this person's been really loyal, and they're okay, they didn't grow up with computers, they're not great with technology, it's a data-driven world, and I want to get a couple like recent students out of college to come work for me. I can hire 2 of them, pay the 2 of them less overall, And they should be more productive than this 50-year-old that's working for me. So we have businesses doing this, and does that sound fair? No. And so you cannot just let them go because of their age. Now, certainly this happens all the time, where we see if you come in, there's a lot of ways you can tell someone's older, even just from their resume. You know, in their resume, they say, I have over 40 years experience in the management field. How old do you think that person is? Maybe 60, right? So usually I actually advise a lot of the people, 40 or older people that I work with, you don't have to say 40 years. What's the difference between 20 or 40 years of experience? Just put 20 so you're not dating yourself on your resume, right? And not getting the opportunity even to come in for the interview. Then you come into the interview and they see your face, right? So there's this older generation where they're having trouble finding work because they're not going to tell you that's not why they're not hiring you, but they're seeing you, this older person, and going, I'm concerned, right? This person's going to be out on medical leave, or this person's not going to be as fast. And so there's certainly issues with this. But this law was here to help prevent against that. Now I want to talk about the flip side of this. You guys know I was really, really young when I was in college, and I had to work to pay to get through college. So I was a manager at a restaurant and then a manager at AT&T. Again, it was when the iPhone came out, just to date myself a little. So I was, I gotta not give you the wrong, I was 19 when I graduated from UMass with my bachelor's degree, and I started working as a manager at AT&T. So was I old enough to drink alcohol? No. And do you think they normally would have wanted to have a 19-year-old running one of their big stores?
No.
Probably not. Yeah, but they didn't know that when they were hiring me. Often the person who's doing the hiring is different and apart from. It's a manager, and they're apart from the human resources. So they hire me, and then I give them all my paperwork, and that manager never knew that I was 19 there. And the way he found out was I wasn't old enough to legally drink, and he kept being like, wow, your store's doing really well, let's go celebrate. I'll buy you guys some drinks, and I couldn't drink with him legally, right? So finally I had to tell him, like, I'm only 19. He fires me at that moment. He didn't really, I'm just giving an example. He fires me at that moment. You guys look so shocked. He fires me at that moment. Do I have a legal right to do anything? Under what? Age discrimination, Employment Act says who's protected.
40 years or older.
Okay, so remember, I can be fired, let go for any reason unless it's discriminatory. Was that okay for him to let me go? Yeah, like the smoker, it's not a protected group, right? He could have let me go. Scary, right? My only argument would be something like, I'm a woman, you fired me because I'm a woman, right? But that wasn't why, if it was my age. He didn't fire me, don't feel bad, he just didn't give me that drink, okay? So, Age Discrimination Employment Act, it does protect older workers. This isn't designed to help some of the younger workers experiencing issues like this in the workplace because it's not really as prevalent. Now over here, this is a really big one, and again, this applies to the workplace and schools. The American with Disabilities Act. What this says is a disabled person is someone who has, the law is saying someone who has a physical or mental disability. And they define this impairment as something that substantially limits a major life activity. So to figure out what would be a substantial limitation, they're going to look to prior case law. So for example, if I have arthritis, is that going to substantially limit my ability to do this job? Probably not, especially if it's only one hand. Unless I need my hands to play guitar, I don't need to play guitar for you guys. I'm not going to sing and dance the material. There are teachers that do, I'm just not that cool. Okay, so here, substantially limiting a major life activity, so it needs to qualify as an actual physical or mental disability that would be a major life activity that's being impaired. Now, because of that, employer, and your school as well, should be making what we call reasonable accommodations. Okay, they should not be turning you away from a job, and they should be making reasonable accommodations. Now the problem with this is it has to be reasonable. It can't put an undue hardship on the business. So for instance, if I have a job where I need to be on the phone all day, but I just told you I have arthritis in my hand, so it's hard for me to hold the phone like this all day. What do you think would be a reasonable way to resolve that? Anyone, raise your hand. Allison.
So put the phone on speaker.
Okay, speakerphone. That's pretty simple, right? Any other ways we could resolve that?
Bluetooth.
Go ahead, Sebastian. Headset, yeah, Bluetooth, I hear people saying in the front. Yeah, a headset. Is that expensive?
No.
Not unless you're getting the Bose or the, it's going to be like $10, $20 to get a cheap pair of headphones that'll do this job, right? So that's what I mean by a reasonable accommodation. Okay, if you have something going on that's a major life impairment and it's going to mean they need to do significant changes to the office, it's going to cost them $1 million to do it, that could be an undue hardship on the business. They don't have to meet that requirement then. Now, you have to be able to do the requirements of the job, and if you can't do them, and they can provide a way for you to do them at a cost-effective way, they're supposed to under this law. Now, the way businesses get around this, just want to make sure you guys see the practical side of this. A lot of businesses will write in their job descriptions things like, must be able to lift 30 pounds to do this job. 50 pounds sometimes too. Anyone seen that before?
Yeah.
Yeah, that's their way to get around this a bit, because if you think about it, is this woman going to be able to lift a 50-pound box easily? No. So now they've said, well, you can't meet the demands of this job, and is there reasonable accommodation that would resolve this? Not really. So that's how they get around this issue. It's not great. From an academic side, because you're students, if you have a physical or mental disability, and it's a reasonable way we can help you to have a better learning experience, schools have a disability office where you don't have to even tell your teachers what the disability is. They'll give you a letter that says these accommodations need to be made. Okay? And then you show your teacher that. Your teacher doesn't need to know why. You have a conversation, and then you have those reasonable accommodations made, and that's fair. You know, I've known people who they need double time on tests, you know, because of an issue, a mental disability, and that's fine. You know, that means you should receive that accommodation. And the problem I get a lot with students who experience that is they'll be like, oh, it's fine. You know, I can just do the test in class, and I'm going, well, I don't want to put you in a bad situation. It's a reasonable accommodation. You know, you have the right to have that. Have that. If you don't need the whole time, great. You know, I don't want you to run into a situation where you're getting a bad grade, and it's not fair to you, because you're supposed to have that accommodation. So your teachers are supposed to meet those accommodations, and if you run into issues with that, you should say something. Now, how do we prove there's been discrimination? Remember, because you can let people go at any time for any reason, right? So there's two forms of discrimination. You want to write them both down. This is something you'd probably see on the exam. What's one of the forms of discrimination? What's it called? Good, Delia said disparate treatment. Okay, this is what we think of when we think of discrimination. It's like this intentional treating someone differently because of the fact that they're 40 or older, because of the fact that they're a woman. Okay? Over here, disparate impact is a little different. This is unintentional. Okay? It's not that you meant to be discriminatory. You had some type of policy, and as a result, one of these protected groups was not treated fairly. So it doesn't mean you meant to be mean and that you're doing something nasty, but if there's discrimination occurring, whether intentional or unintentional, you can have a claim under the Civil Rights Act. So let's look at intentional first. Okay? To prove disparate treatment, you have to show that you were treated differently because of one of those 5 groups. Okay? Sex, race, color, religion, or national origin. That's hard to show, right? It's hard to know when you go in for that job interview that you were not chosen because of your gender or because of your race or because of your national origin. Unless they blatantly say it to you, you're going to have a difficult time evidencing that. So it's a hard thing to prove. Okay, but that is one of the protections that's in place. That's a little different. This is unintentional, but again, we see this discriminatory result. And so this applies if the employer has a rule that on its face is fine, not discriminatory, but discrimination's happening anyway. So I want to give you an example of that, okay, with the Griggs versus Duke Power case. Now this was a really important case. Remember, we talk about precedent all the time. The Civil Rights Act said disparate treatment, intentional discrimination is not okay. Right? That's really what it seemed like under the law. Does it say unintentional discrimination matters too? So the Griggs case was the one where we saw the court saying, yes, under the Civil Rights Act, it's both intentional and unintentional discrimination is included. Even though they didn't specifically say that in the Civil Rights Act, we're going to construe it to mean both. And so in the Griggs case, I want you to keep in mind the time here. And this was a long time ago. This would probably have a different outcome today. So before Title VII, Title VII came to be in 1964. So just to give you some context in terms of the date here. Before 1964, Duke Power hires black employees only in its labor department. In that department, they're not paid as well as these other kind of better departments where they have all white people working. Seem fair? No. So the Civil Rights Act comes down and says you can't do that. You can't treat people differently because of their race, right? So they make this change and they say, we're going to require all new hires for jobs in those desirable departments to take this test. And it's not based on whether or not you can do the job, it's based simply on your IQ and on your skills. Okay, but we're going to have you take this test, and you need to have a high school education. Does that seem okay? Yeah.
Yeah.
Anyone apply to a job that says you need to have a high school diploma? Yeah, and you're in college right now because there's many jobs out there where you need to have a college degree, right? And is that discriminatory?
No.
No. So here they're saying high school diploma, or you need to meet these test requirements to show you have a certain IQ level, certain skill level. Still, as a result of that test, the pass rate for whites was actually much higher than for blacks. And blacks were also less likely than whites to have a high school diploma at this time. There was a lot of segregation in the schools. There were a lot of issues going on. We're back, remember, 1960s, 1950s. And so it was harder for them to meet that high school diploma requirement than it is today. Now, the new policy did not apply to the exclusively white employees who already had those desirable jobs. So it was only when there was an opening. What was happening was, even though they weren't saying no black people can be in these desirable jobs, as a result of the high school diploma requirement and the test they had in place, and because they let all the other white people keep those jobs, black people were not getting to be in the desirable jobs still. Is there intentional discrimination? Maybe, not sure. But does it seem like there's still a group being treated unfairly? Yes. And that was what the law said as well. Okay. In this case, they're like, this just doesn't seem okay. And so here we see an example of where they're saying the Civil Rights Act includes not only intentional discrimination, if it ends up as a result that a group is being treated unfairly that's supposed to be protected, we're going to treat that as discrimination as well. We call that what? Good. Riley said it, disparate impact. I saw a hand over here. Eduardo?
So the white people that were working there, they didn't have, some of them didn't have also the high school diploma. That's what is the issue.
They just didn't have to. So if you didn't have the high school diploma and you hadn't taken that test, it wasn't like they were going to fire you because of it. You got to keep your job. It was only for new incoming employees. So we saw this here. They decided to make it so the Civil Rights Act looked into both forms of intentional and unintentional discrimination. Now there are some defenses to that. Employers get hit with these claims all the time. Because whether you meant to discriminate or not, someone can argue that you did, right? They can bring a claim in court. I could bring that manager from AT&T that fired me. Remember, again, I didn't really get fired. I can bring that manager and I can say it was because I was a woman, and he'll say that was not the reason, but I can still bring that claim. And so here's the defenses the employers have. This is the big one. It's called a bona fide occupational qualification, a BFOQ. I'll be honest with you, this rarely is upheld in court. Okay, it's an option, it's a defense, but the court doesn't look very fondly on it. And what this is it says employers are allowed to establish certain discriminatory requirements if it goes to the heart of the business. So for example, there has been a case where Hooters was allowed to discriminate. Generally, what is that business about? It's a sports bar, right? And who do they generally hire to serve the food at that sports bar and drinks?
Bigger.
Girls with sexy women. Is that fair? Sexy women. So if I'm a man and I go to get that job, are they going to hire me?
No.
Probably, yeah, to cook, right? As long as you're behind the scenes, right? So we want sexy women working there. That's what we would call like a bona fide occupational qualification. And you only want sexy women in your restaurant because of the atmosphere. Generally that's not going to fly because, again, the courts don't generally uphold this. Normally they're going to say that's discriminatory, and technically a man could bring a case and say, well, I want to be a Hooters server too, right? Let me give you another example. Raise your hand if you've heard of or flown on Southwest Airlines. Seriously? I've got like half of you? Okay. They're pretty cheap. Okay. So Southwest Airlines, they're known as like the love airline. And you probably have seen this in their branding. They have some hearts and things. So if you didn't know, they used to be the love airline. They were almost like Hooters of the Sky back in the day. They wanted to cater to businessmen. And so they wanted to have sexy stewardess serving you the drinks and stuff on the plane. If I go on a Southwest flight today, will there be a man serving me my drink possibly? Yeah. So there was this case where a man said, well, I want to be able to be on that plane being a steward. That's not fair. And they brought a lawsuit and said, that's discrimination. I applied for a job, and you didn't hire me. You hired Catherine instead because she's a woman. Okay? And you didn't hire Milton because he's a man. They both wanted that job. You're violating the Civil Rights Act based on gender, right? And so they defend themselves, Southwest, and they say, well, this is a bona fide occupational qualification. You know, our airline, it's this atmosphere of sexy whatever, you know, for the businessmen on our airline. What do you think was the outcome in that case in the court? Who won, Southwest or the male steward? The male steward, right? Because we know today, are there men on Southwest flights?
Mhm.
Yeah, so they said, we're the love airline. What is the heart of Southwest business? What is the business doing? Flying. Thank you, Jonah. They're flying you from point A to point B. It's not about the sexy women in the air serving you the drinks on the plane. So the court did not uphold that bona fide occupational qualification. Okay? Just like at Hooters, you know, what is the heart of their business? The wings are good, right? Yeah, the wings are good. So the way this works, the rare exception is things like if you work in a women's prison, and you want to hire women guards. You know, that's where this might be upheld. Or it's a locker room and they want to hire a woman in for the woman's locker room at a woman's gym. This could apply. Now, again, we're having a lot of transgender issues around this, so who knows what will happen going forward. Go ahead,
Yeah,
Deborah.
that's like based on your looks. I know my sister took her on my course and she had a friend that wanted to apply there, but the manager didn't hire her because she didn't have like the right look.
Yeah, you know, not having the right look. You could argue it was discrimination based on the fact that you're a woman. It's going to be a hard argument if they just hired a prettier woman, right? Because there's no protection, there's no law that protects ugly people. So. Eduardo, question.
So is it the, so to be clear, is it the transgender protected under the law or no?
Yes, so transgender is not spelled out as one of the protected groups, but it's protected, it falls under which of the five? Gender. So they've construed the law, they've defined that group to include transgender. Other question, Delia?
Yeah, because I was gonna ask a question, because we're at work at the restaurant, right? Because we have like a line, and we need to hire a cook, but for some reason there was a cook who was trying to apply, but he was really big. But the line is just, you know, like you have to be a little skinny in order for you
Small
to work.
kitchen,
Yeah,
and
small
large
kitchen.
dining.
So we didn't, even though he has the qualification and all that, we
So
can't.
was that discrimination?
Because that means we have to
No.
extend the
You have to, you can say that. But
To try to make an argument that that was impairing a major life activity, going back to the American Disability Act, probably gonna be a hard stretch. Okay, if it's a small kitchen, it wouldn't be reasonable to ask the kitchen to do a full renovation to fix
Yeah.
that. So it's not, I told you the law's not always fair. Another defense is merit. So if someone says you're discriminating, the company can say, well, no, you know, we did not make that decision based on the fact that this person was a woman or based on the fact that they're white. We made that based on the fact that, you know, they had the best qualifications. Now here's where this fails. If I hire a white person instead of a black person and the black person had 20 years experience, multiple degrees, and the white person has like 3 years experience and no degrees, is it really based on merit?
No.
No. So you really need to make sure the person you hired actually had, you know, better credentials. And the last defense is seniority. There could be a legitimate seniority system that says, like, we are going to promote from within. You know, that's okay. That's okay to do. So you could promote the man instead of the woman coming from the outside because that's a legitimate seniority system. The company has a policy where they try to promote internally. Go ahead, Senya.
You can say that languages could be a bona fide occupation qualification.
Language.
Yes. Like
Language
if
is
you
a
are
tough-
requiring a people that have bilingual.
Language is a tough issue. So if you, I was a manager, that first restaurant I was a manager of, I had to manage Spanish employees and I did not speak Spanish well. Okay? They could have made it a requirement of the job that I be bilingual in Spanish, and that's okay for a business to do. If it's really something necessary to do your job, they're allowed to do that.
Yeah, I was thinking like a Mexican restaurant that you say that your employees are speaking Spanish and you have also customers that only speak Spanish. You can say that.
Yeah, companies, if they want to hire someone who speaks a specific language, they're allowed to say that in the job requirements. They need it to do the duties of the job. You know, certainly a lot of businesses, they need to be be able to communicate with their customers, and not everyone speaks English, right? That wouldn't be fair. So we need to make sure that we also hire people who can speak other languages, and they're allowed to do that. I know many of you in this room speak not only English very well, but also multiple other languages. That's a benefit to you. That's a good thing for you on your resume then. So moving forward here, I want to show you a couple sites. Okay, the Equal Employment Opportunity Commission, what are they? I told you earlier in class, and you did the reading. What's the Equal Employment Opportunity Commission?
That's an agency.
It's an agency, and what were they designed to do? Good, protection for employees. I just told you you have all these protections against being discriminated against. Is a lawyer expensive?
Yes.
Yeah, we need to make sure that workers are able to actually bring these claims if they're experiencing this. And that's where, under the Civil Rights Act, they created this agency known as the Equal Employment Opportunity Commission. And this agency, it's their job to help prevent and protect against discrimination in the workplace based on the Civil Rights Act. So here, when you click on that link on the Prezi, you'll see you can file a claim on this site. And they will assign an attorney to your case that works for the agency. You don't have to pay for that attorney. So this is a great resource if you're experiencing any of the issues we talked about in class today. Okay? Normally, they'll try to resolve the issue through mediation. Remember, most cases are not settled in the courtroom. So you'll see they'll try to work with the company, work with you to come to a good solution without having to spend years and years arguing in court. The other big resource I want to show you, I'm a huge fan of this, is the Workplace Fairness site. Workplace Fairness is a non-profit organization. When I worked there, they had over 3 million users on their site. It's a pretty big site. It's well used. And I'm a huge fan of this. I wrote for them a little bit in law school as an internship, and then later on they invited me back to serve on their board. I served on their board for a couple of years until my daughter was born as a volunteer thing because I wanted to help them because they are doing a great thing. They spread awareness about your rights in the workplace. And what they do is they take all the legal jargon out. You guys are on this business law class that you got introduced in just a couple hours to some of the protections out there. Okay, but you don't always know all the things you're experiencing on the job if it's okay or not. Okay, and the average person doesn't always take a business law class and even get introduced to those concepts. So here, both for employers and for employees, they're saying here's some of the laws around that. We all work. It's good for you to know what protections are in place. And I love that they take the legal jargon out so they make it really easy and clear to understand. So you guys learn some stuff. You can tell your friends, tell your family. If anyone's experiencing something unfair, this is a great place to have them go look to, this website. So for example, I have a lot of students who have had issues with pay. And so here, I can click under Know Your Rights. We'll give it a minute to load here, and they'll see different areas where there can be issues. Final paychecks, deductions from pay. We've talked about minimum wage a lot. Who in here is a tipped employee? Like you're a server and you receive tips? Anyone? Okay, I got a few. Okay, a few of those. Tipped employees. If you want to find out information about your job, you can click on that area. And what is really neat about it is it brings up like a Q&A format, questions and answers, and they don't have a bunch of legalese that's hard to understand. So here I can see like which federal law covers tips. And I'm going to see the Fair Labor Standards Act here, which we learned about earlier in class, where it speaks to minimum wages. And then I'm going to see things like which employers are covered. Can my employer pay me less in wages because I receive tips? So you'll see, do you make $7.25 an hour as a waiter or waitress? No, your employer is usually paying you like $2, right? It's like nothing. But then in tips, you're supposed to, if you combine that $2.13 an hour plus your tips, you should be making more than the minimum. If you don't, you can actually file a claim and get your employer to pay you more. If your tips are not averaging out to that $7.25 federal minimum, or the state and local, you can get the employer to do more. So here, this is where you see this type of information, all these questions and answers. So you have a lot of great resources on this site. You also have the ability to ask a lawyer for help. So it's a good way to get more information if you have any issues about anything we talked about today in class. Now I'm going to stop the video recording here, but I'm going to show you one activity we're going to do together as a class now. Let me just save this.